È bello avere quello che ti serve quando ti serve. Con EasyBank, la banca digitale di Intesa San Paolo.
E allora si è voltato improvvisamente alla gente che era lì e ha detto: la gente che cosa dice che io sia? Chi dice che io sia? E voi chi dite che io sia?
È bello avere quello che ti serve quando ti serve. Con EasyBank, la banca digitale di Intesa San Paolo.
E allora si è voltato improvvisamente alla gente che era lì e ha detto: la gente che cosa dice che io sia? Chi dice che io sia? E voi chi dite che io sia?
Civiltà dell'amore, fratelli e sorelle, costruite senza stancarvi mai questa civiltà. Lavorate per questo, pregate per questo, soffrite per questo.
Avere quello che ti serve quando ti serve. Con EasyBank, la banca digitale di Intesa San Paolo.
E allora si è voltato improvvisamente alla gente che era lì e ha detto: la gente che cosa dice che io sia? Chi dice che io sia? E voi chi dite che io sia?
Avere quello che ti serve quando ti serve. Con EasyBank, la banca digitale di Intesa San Paolo.
E allora si è voltato improvvisamente alla gente che era lì e ha detto: la gente che cosa dice che io sia? Chi dice che io sia? E voi chi dite che io sia?
civiltà dell'amore. Fratelli e sorelle, costruite senza stancarvi mai questa civiltà. Lavorate per questo, pregate per questo, soffrite per questo.
Buongiorno.
So good afternoon and welcome to this meeting in which we are honored by having with us the President of the Italian Constitutional Court, Augusto Barbera, whom we would all like to thank. After a short introduction of mine, I'd like to leave the floor to Mr. Barbera, who will talk about the work of the Italian Constitutional Court in this very moment. At the Rimini meeting this year, we have tried to, in a way, bring together institutional topics with social and economic topics. One of the topics we've dealt with these days was the growth of inequalities and poverty in Italy, and the fact that absolute poverty concerns 1.7 million households, especially in southern Italy. And the economic model risks to generate both environmental and also human waste, as Pope Francis says. We've also addressed issues related to the topic of development. The development needs to recover, to start again. We also addressed issues related to the public debt. What does all of this have to do with politics? In democracies, politics and institutions are those relations that represent everybody that deal with these problems. In other words, they in a way generate rules where people can live better. So we have a constitution that was envisaged in a very peculiar way as the result from ideologically distant parties, which, however, have been able to give our country some common rules, enabling it to grow. When it was drafted, not only did we have this, but besides the written constitution, there were parties which were deeply rooted in society, so deeply rooted in the Italian people. They, in a way, completed the Constitutional Court. These parties completed the Constitutional Court and the Constitution, and they were fundamental to guarantee development. This has gradually started disappearing. So there are less and less parties expressing the popular will, and therefore the topic we address, the topic we would like to address during this talk is how our constitution, in other words, the constitution that the Constitutional Court makes lively each and every day, can serve as a stimulus for this recovery, something that can help enhance and promote all bottom-up approaches. So a constitution that can promote the presence of the state anywhere, as well as the free market, as well as all those forces which in Article 2 of the Italian Constitution, which completed the picture back then. So we don't have so many answers, but we have a lot of questions. How come that three forces, so the market, the state, popular movements and social movements, how come that these players contribute to relaunch the country, help recover the GDP, fight against inequalities? Of course, this is not the task of the Constitutional Court, but it's interesting to see how the Constitutional Court sees and interprets the Constitution. That becomes a way through which citizens' lives are enacted, take place. That is why we drafted some questions. They are meant as a provocation, and then President Barbera is free to answer and to stress the aspects that he believes are the most interesting ones. And the first one is that of a constitution that basically has the human being at the core together with the state. And the human person is at the center, and as such, this has enabled the state to grow as a democracy. We have a very interesting exhibition on Alcide De Gasperi here at the meeting, and this leads me to talk about Article 2 of the Constitution that directly reflects the dialogue between La Pira and Togliatti, who managed to play the human person at the center precisely with that very articles. How can we defend individuals? How can we defend the human person in the view of the Constitutional Court? And second, as these people, as these individuals live within social communities, the Constitutional Court has done pioneering work in relaunching Article 2 on social organizations. So there was a constitutional reform of 2001, so Decision 131 of 2020, which redesigned co-designing and co-programming between public administrations and the third sector. So that's the idea that the state is partner of these social realities. And that's a second topic, which is very much interesting for us. And then the third point is the balance between powers. In other words, our Constitution has a legislative, a judicial, and an executive power. And this idea of the individual and social formation, social organization, leads to the role of Parliament, and Parliament does not necessarily appear to be at the center. This in turn leads to the overall structure of the state, so the organization between the organization and the breakdown in regions, and then all the reforms that are currently being discussed. And then in turn this relates to the current idea of reforms. Should reforms be done in piecemeal or as global? Should they be conceived as global reforms? Of course, this impacts the lives of people. However, if politics and the institutions support this kind of measures, and if the court has an independence that, compared to that of other countries, is a very big value, this can support this pathway. These are my provocations to you, President Barbera, but you, of course, are free to structure your reply as you deem appropriate. First of all, I would like to thank you for the great honor that you paid to me and that you are paying to the Constitutional Court, inviting me to this wonderful days of the Rimini meeting. This is not the first time I am attending the meeting, and I very much admire the plurality of views, of cultural views, and the magnificent organization. So congratulations. I've known Mr. Vittadini for quite a while, and Mr. Vittadini has an extraordinary capacity. When he talks, he basically disrupts all the ideas that you originally had in mind. But that's very challenging. That's really stimulating. So let me address the first point. Let me talk about the crisis of political parties. Can I call you by your name? You said that political parties are in crisis. You said that they do not actually represent the problems of the country. That's indeed a real problem that affects the whole Western world. And that depends on the fact that the parties that we could talk to, that were set up years ago, were set up within the framework of cleavages in society. So they were set up in the cleavage between the bourgeoisie and the proletarians. So that was the moment in which people were going from, there was this shift between agricultural society and industrial society. They were left-wing oriented parties which were trying to bring about the interests of the working classes and middle-class parties. So we had the Social Democratic Party, the Labour Party, the Liberal Party, the Conservative Party, on the other hand. In Italy, the situation was a bit different because Italy had come out of the fascist regime. And soon after, it was involved in the Cold War. And in that moment, there was a party, an Italian party, the Christian Democrats, which eventually went into crisis with the fall of the Berlin Wall. So there was no longer a cleavage. That moment was took place when society went from being an agricultural one to an industrial one. And now we're entering another stage. We're entering the digital stage, and we do not know what the cleavages are and where it is possible to set up associations. So there is a bipolarization, a bipolar system. In democracies, normally you have this tendency to have to stand on the one or on the other side. And the trend is in favor of an ethical bipolar position. So on the one hand, you have those who are in favor of the ethics of values, and the other one are basically the ethics of the family ethics of value, the rights ethic, the belonging to a community, traditions. This is one pole of this ethics bipolarity. And the second is the ethics of rights. So the value of life, but personal decisions on the end of life. So life is an absolute value. You cannot intervene. On the other hand, you probably remember Indro Montanelli, who used to say that he wanted to have the right to put an end to his life when he wanted and how he wanted, as well as a full availability of one's body, the free expression of sexuality, personal identity, gender fluidity, then the full expansion of inclusion rights for immigrants, migrants, and the marginalized. So on the one hand, can you hear me? Can you hear me okay? So this is the bipolarization, so the ethics of values and the ethics of rights. Certain rights should not be touched, and rights should be developed. Those who are in favor of the ethics of values are in favor of conservation, and the others who are in favor of the rights of the ethics of right are in favor of progress. Well, there are some people who adhere to this division and to this representation, but I'm not that much of sharing this view, because sometimes these two different ethics intertwine and sometimes they overlap. So, and that happens to political parties who are on the right and on the both right-wing and left-wing political formations. Let me give you an example on this. Nobody says that the value of life should be protected at any case without taking the will of subjects, of players into account, and without considering, for example, the patient's right to decide the form and timing of his or her leave for absence. And the same applies to the family. The value of the family or the natural society, that's the subject of Article 29 of the Constitution, or, again, when it comes to families, should one consider the right of a couple, even a same-sex couple, to form a community of affection? The solution that was found recognizes one right, and that's also thanks to an article of the Constitutional Court. The decision recognizes the social formations. However, these formations are not considered real families as intended by the Constitution. This is at least what was debated politically. At the same time, we have the drafting, so to say, the outlining of a new habeas corpus act, which since 1215 is basically a legal thought according to which one has to protect the body from external physical compulsion unless the judiciary provides for this to be the case. And now the tendency is to have a new habeas corpus act, so according to which everybody should have full and free availability of one's own life. These are all things that I'm going to address. So you have this tendency, this bipolarity that is typical of a society which is basically shifting towards a digital society. The shift from agriculture to industrial society brought with itself lots of negative events, casualties, and then in the end it got stabilized. However, the shift that lasted more than 1 century, it was not easy at all. We are just at the beginning of this shift from the industrial society to the digital one. What does all of this has to do with the title of our talk, which is the Constitution in a common good? By common goods, we mean something peculiar. And this leads me to a specific topic, that of the essence. So constitutional principles are the essence of a legal system. However, we should pay attention and avoid that, as Aristotle said, essence should not coincide with accidents. In other words, what's essential has to be preserved and defended. What is not essential can be adapted and reformed. I'll be clearer on this. There are some parts of the Constitution. There's the first part of the Constitution, which is the fundamental part that focuses on rights, and then the second part is also important. However, that has to be reformed. And as a matter of fact, since 1983, we have been trying to reform the second part of the Constitution. Back then, we had Mr. Spadolini with his law, then the Bozzi draft, then the NITA committee, the Iotti committee, the D'Alema committee, and then the Commission of Wise Men set up following the idea of Gentiloni. These attempts remind us of a game and I really hope that the best solution is found. So, fact is that we are keeping, we're having a parliamentary system that is installed, but a real one. Or, for example, the direct election of the prime minister or of our president. However, fact is that we need to find solutions. We cannot continue working and playing like that. So bipolarity, that ethical bipolarity. In other countries, there are some difficulties. So, for example, the expression common good is very much it's very much fashionable in the United States today. So the good constitutionalism, the idea is to find something in between originality. For example, those who say that the Constitution is original in its form as drafted by the Constitution first drafters, by our founding fathers. The other tendency tends to adapt the Constitution to our changing, ever-changing society. These are problems which are a hot topic for discussion in this country. The good constitutionalism, with reference to common goods, tends to identify goods that are not written in the Constitution, and they are identified in general principles such as peace, justice, and so on. So there have been people who said that this is done with a new tendency that is typical of labor law. We Italians have our common assets already indicated in the constitutional text. And basically, around those common goods, we have the possibility to overcome the harshness of that ethical bipolarity I was mentioning before. First of all, the primacy of the individual, that's Article 2. So the state works for the person and not the other way around. It's not the person, individual, who works in function of the state. Then the duties and social responsibility of the individual. Subsidiarity, that has always been, and this in particular refers to Article 2. So this sense of openness of the person, of the individual. However, in 2001, we had this possibility. Also, thanks to the actions carried out by the Foundation for Subsidiarity and by the tireless work of Giorgio Vittadini. In our constitution, we are entering the field of subsidiarity. In other words, the state should not do what a private entity can do. And subsidiarity is a way through which people can express their view. I would also like to say that there are some of our trends, some decisions of ours that have touched upon this topic. Then common goods, the common assets, the value and dignity of work. The Italian Republic is founded on work. Then Article 4, the right to work, free private initiative. At the same time, however, the possibility of limiting free private initiative to guarantee social rights as well. Then the principle of equality, the prohibition of discrimination based on sex, race, and religion. That's Article 3 of the Constitution. Then the repudiation of war and a culture of peace. That's Article 11 of the Constitution. Then openness to international organizations. That's yet Article 11. So pluralistic information, free and pluralist information. Information does indeed have problems. On the one hand, you have lots of information that can influence everybody, and then you have this anarchy in social media, which is really sort of spoiling information. Then the enhancement of parties and other social autonomies. These are the common goods of our communities, and they represent a reversal, so to say, of the principles that were typical of the previous state. So in the fascist state, in that case, you had the person as a function of the state. The person was seen as a means and not as an end. You had the exaltation of the hierarchical principle, the exclusive family function for women, then the single party, and war as hygiene of the world, and then the rejection of international ties. I found it really very, very interesting to read point 9 of the Manifesto for Futurism by Marinetti. He said, we want to glorify war. Then militarism, patriotism, then the nice things, the good things for which everything moves, as well as disregard for women. That was Marinetti. There was women were referred to in among futurists as a family-related profile. So we took these values, and these enable us to. So these common goods, these assets, enable us to balance them with rights. There is no bipolarity, at least for our constitution. There is no distinction between the bipolarity of ethics and the ethics of values and the ethics of rights. Both stances. The Italian Constitutional Court, well, actually, I would have liked to talk about the court, but I think I couldn't do it, and plus, I have a very huge timer in front of me. That's actually terrible. That's indicative. So as I was saying, we implemented a number of initiatives which are very important for the economy and society. For the economy, so for example, the recent decision, we have we imposed measures in the taxi sector. And then important decisions were also taken for the modernization of civil society. Here, interesting decisions on the double parental surname. So the exclusive reference that was part of the Italian tradition was no longer in line with gender equality and also with the increased presence of women in society.
I cannot dwell on this aspect, but I would like to mention in particular, in order to pay tribute to Mr. Vittadini, I would like to point out two judgments, number 72 of 2022 and number 191 of 2022, 2 years ago, because there are important statements on the strategic role of the third sector and interesting words on volunteering. And I quote, "Openness to the needs of the others that emphasizes the relational nature of the human person." And then openness that gives meaning to one's own existence and the value of the person by opening up to the needs of the others. So these are two judgments in which we cherish this new value that was highlighted on the basis of the value of the individual in 2001, but it was included in the substance of the constitutional values. So these common values are already included in the text of the Constitution. So it is not necessary to find them elsewhere, and they enabled to the Constitutional Court and to the political debate, I would hope, to avoid a juxtaposition between the two poles. For instance, as actually there would be several decisions to be mentioned, and I would like to remind you of the most important one, the ones on the end of life, the most recent one, with which we also reminded of several orientations already taken for the end of pregnancy, and then the decision with which we took a stance on the gestation for others, the uterus for rent, so to say, and then the recognition of the third sex, prostitution intended as a right by some people, and on the affectivity of prisoners. So several sentences, several judgments that are quite interesting. So the court managed to escape a paralyzing bipolarization between values and rights. The simplest one is the one referring to the end of life. So the value of life, but in some cases, the possibility, without giving way to euthanasia. We must not forget that the Constitutional Court, with some controversy, had already declared a referendum question that wanted to extend the euthanasia. So, not the right to give oneself death, not the right to give oneself death, that was not recognized, but an aid to die or an aid in dying, which are different from one another. And we tried to put together the two needs. I saw that there was an interesting openness by Monsignor Vincenzo Paglia from the Pontifical Academy for Life, and I mentioned from La Stampa of the 8th of August. It seems to overcome positions that in the past marked the presence of non-negotiable limits and instead shows interest in a dialogue aimed at identifying a space for Parliament to be able to make the best choices, which take into account, and I quote, different sensitivities, cultures and religions. So, a message for the Parliament, which is on a standstill when it comes to this point, to this item. I will not dwell on the juridical aspects, but the Constitutional Court had been assigned this topic, and it had to postpone the decision in order to give time to Parliament to intervene. The Parliament had not managed to take any decision due to obvious reasons linked to the difficulties to come to an agreement. So the Constitutional Court had to intervene with the first decision, finding a balance, stating that the value of life is untouchable, but in some cases, nonetheless, it was possible to have assistance it is possible for a person to be assisted to attempt to live this life. There were 3 conditions that were identified and indicated. These 3 conditions did not appear to be easily viable, easily to be put into practice. Some local health facilities did not know how to proceed. Some regions tried and issue laws because they have competence when it comes to healthcare. In the end, the Constitutional Court was addressed, and it adopted the solution I mentioned. The 3 conditions indicated in the first judgment were a patient fully capable of taking decisions, that were making free and conscious decisions, that this patient is suffering from an irreversible pathology, a source of physical and psychological suffering that the patient considers intolerable, and that the patient is kept alive by life support treatments. And this reference to the life-supporting treatment was meant to be only a reference to the machines, so there were problems. So with a more recent ruling, we tried to intervene, extending the life support treatments to other possibilities. Someone stated that we took steps ahead, but the right that was requested was not obtained, and some other thought that the step taken was not respectful of life. We've tried to strike a balance between the value of life, which remains fundamental, and the right of the patients, by recalling some orientations of the previous years when it comes to end of pregnancy. There was a judgment, 27 of 1975, sorry, number 194 of 1978. In that decision, and in the law enacting that decision, that sentence, no one speaks about the right to interrupt pregnancy as exercising a freedom right, but in striking a balance between the right to life of the would-be newborn baby and the right of the mother, there was a recognition of the right to therapeutical self-determination of the mother. So there was a way to put together values and rights. And this was useful when it comes to the decisions on the end of life. There are other decisions I could mention. I'm always looking at the timing, at the chronometer. There would be many other decisions I could mention, but going rapidly, the gestation for others. I would like to remind you of a sentence in various judgments, 272 of 2017, 33 of 2021, and 79 of 2022. Surrogacy. The practice of surrogacy intolerably offends the dignity of women and deeply undermines human relations. That's a definite, decisive closeness to the surrogacy, without making any distinction between the gestation as a result of a market-related negotiation and the pregnancy for others based on solidarity. So no distinction of this kind has been made. This position of the court was decided, and it was repeated in several judgments several times. But the court also invited the parliament so that the parliament caters for the rights of the kids of same-sex couples. So writing the conditions, and this is a task of the legislator, a new type of adoptions. Since the current adoption is not completely useful in this case. We've repeated it several times. So on the one hand, there was a no to the gestation for others, but on the other hand, it is not possible not to recognize the rights of boys and girls, sons and daughters of the same-sex couples. So the value of the person protected by Article 2 of the Constitution require both the prohibition of this intolerable practice, that of the gestation for others, and the pursuit of the best interests of the children. Best interest. As this is stated in the International Declaration of the Rights of the Child. So an invitation to the Parliament to take care of this topic, not leaving everything to the chaos of the various offices of the various municipalities. But we must be careful in this respect. We should not fall prey of an optical distortion. The court, with this, reminds of to the Parliament, intends to recognize a child's right to have a place in affections proper to family nucleus. It did not intend to recognize the gestation for others as compatible with the constitutional values, but it did not intend to recognize as constitutionally guaranteed rights either to parenthood, right to parenthood, or a right to procreate. They deserve protection, of course, but they are not susceptible to be implemented at any cost and without limits. Not at any cost and without limits, using all the tools, etc. There was a decision, for instance, I see sentence 389, but it was an ordinance 389 of 1988, which stated this principle, referring to the father of a partner of a mother who had decided to end the pregnancy. And he had addressed the judge to interrupt that decision. And in that case, there was a possibility to face this issue. Another decision, affectivity in jail, in prison. This is a very recent judgment, number 10 of 2024. With it, the Constitutional Court declared the constitutional unlawfulness of Article 18 of the Prison Ordinance Act, insofar as it does not provide that a detained person may be allowed to conduct interviews with a spouse, a civil partnership partner, or person living with him or her on a stable basis without the custody staff's visual supervision. It is not a subjective right. Yet, the court stated very clearly that in contradiction with the Article 27 of the Constitution, one of the common goods of our Constitution. So, the penalties cannot consist of, and I quote, treatment contrary to the sense of humanity and must aim at re-educating the convicted person. End quote. Another decision which is useful within this context of decisions, we go back 3 years, a decision in 2018. So in judgments of 2019, the court stated that the choice to sell sex is not compatible with constitutional values. Sexual freedom. Where does it come from? There was a person facing a trial in the Court of Appeal of Bari, been charged with the accusation of exploiting prostitution. And the Court of Appeal had a doubt that it was against the Constitution, because if it is an aid to exercise a constitutional right, why should it be a crime? Why should it be an offense? We know that in our Constitution, even what is legal, if it is not a constitutional right, doesn't enjoy any constitutional protection. So our decision was clear, stating that the free availability of one's body is not a constitutional right. It is not an aspect of the liberty for self-determination. It is a legal activity unless the legislator intervenes. If the legislator intervenes, one of the constitutional common goods cannot be touched. As for drugs, the topic is more complicated. As you know, in 1993, there was a referendum that affected some articles of the single text on drugs, in particular, Article 72, stating the personal use of narcotic or psychotropic substances listed in tables 1, 2, 3, and 4, provided for in Article 14, is prohibited. This was abrogated by that referendum, that of 1993, and undoubtedly it is legal to assume even heavy drugs. Yet there are those who believe that this is a better way, liberalization is a better way to combat the spread of drugs. For others, it is a recognition of a right to freedom. The Constitutional Court did not have a chance to deal directly with this issue. But I would say that it is difficult to make a relation between a constitutional right and the right to take drugs. We know that this is a crime, and it is still a crime. That referendum did not affect the part related to the sanctions. Some believe this is a right to do wrong, the recognition of a right to do wrong, as they say in the US. I don't think this would be the case, but there is no judgment by the Constitutional Court. I don't think it would be accepted. As for personal identity, the last of the topics, we have a very recent sentence, doubts against Article 1 of Law Number 164, insofar as it does not provide for the registry recognition of a non-binary gender, neither male nor female. The objection of legitimacy was declared inadmissible. It did not enter, the court did not enter into the merit, since the possible introduction of a third gender in the civil status would necessarily postulate a systemic legislative intervention in the very sectors of the legal system and for the numerous institutions currently regulated with a binary logic. So, but we must be careful because everything remains there. We did not enter into the merit. And there were some declarations, alarmed editorials. In some cases, the editorials were alarming because there was an opening towards a third gender. In other cases, they were satisfied because we ruled out the openness. We did not do either one thing or the other. We limited ourselves to state that it was a competence of the Parliament, the first interpreter of the social sensitivity. And the Parliament will have to cater for the individual elements. So this is a reference to articles of the Constitution. The working method, how did we reach these conclusions? We always reached unanimous conclusions. What is the method of the working method of the court? The matching values and the rights, fleeing bipolarization. This is a point I would like to underline. It is a key point of my speech. It was possible because it was possible in various ways. First of all, because we have the ability to listen to each other. And there is nobody from the outside, and I would like to thank Giorgio Vittadini, unlike other constitutional courts, from the outside there is no possibility to act or to affect the court because of the way it is composed. 5 judges appointed by the head of state, not on the basis of belonging to a political party, but only on the basis of the evaluation that the head of state makes of their skills and competencies. 5 stem from the Court of Auditors, and they are the expression of those of magistracy. So not on the basis of political criteria, on the basis of internal evaluations. And here, when it comes to the Parliament, there are such high majorities envisaged that only the agreement among various parliamentary groups can enable to elect to appoint a judge. And this is a positive aspect for the composition of the court, but it also entails some problems. It is difficult to find an agreement, to reach an agreement. And I repeat it once again, we are awaiting for the appointment of the judge replacing the former President Shara that had to be replaced several months ago. Unlike what happens in other countries, we saw what happens in the most ancient and glorious of the constitutional courts, the Supreme Court of the United States, since its composition is linked to the President of the U.S. Indeed, there have been some problems, there are some problems, there still are some problems. Luckily enough, this is not the case in Italy. The second reason we reached that conclusion is that our working method is that of balancing rights and values. Based on the Constitution. And thirdly, because we made a distinction between the mere lawfulness of a behavior and its inclusion among constitutionally protected rights. So the last point, we've always tried to find harmony and collaboration with the Parliament. This was not always the case, but we succeeded in the majority of cases. We are the guardians of the constitutions. But I underlined that it is not the Constitutional Court which is the exclusive interpreter of the Constitution. And we want the democratically elected representatives of the people should be in as much agreement as possible. We did not manage to reach this target always, especially when it comes to the recognition of the end of life and the recognition of the sons and daughters of same-sex couples. The very last thing, because I'm always looking at the timer there. So following up on what I was asked, there's always an excessive mention of rights. Rights are constantly mentioned. The point of reference is Article 2 of the Constitution, which states that the Republic recognizes and guarantees the protection of inviolable human rights. According to a certain interpretation dating back to the half of the 1980s of last century, these rights are not explicitly mentioned in the Constitution, but which may be taken out of the Constitution as an interpretation. What we underline, however, is that it is true that it is possible to recognize rights on the basis of the values of the person, but the values of the person are also a limit to the recognition of new rights. The examples I gave earlier may be useful. And finally, the Article 2 of the Constitutional is very much used, and I would like to invite my colleagues, experts of Constitution and the public opinion, is to take into account that there is not always Article 2. We also have paragraph 2 of the Article 3. The Republic has a task to eliminate the obstacles limiting de facto liberty and equality, hindering the development of the person, of the individual. And this cannot be done through the judicial activity. Magistratura Democratica at the beginning had focused on acting through sentences of the Constitutional Court. This is a task of the political power, but if this is the case, the political power must be power able to take decisions, able to plan, not limiting itself only to manage the present issues. It should be a power able to build on the basis of those values that are enshrined in the Constitution. This is a task of the political power. Hence the issue of the constitutional reforms. I cannot say anything about this topic because I am the president of the Constitutional Court. So I need to stop here, and I would like to thank you all for your attention.
Io ringrazio molto il professor Barbera.
Thank you very much to Professor Barbera. As we've often said, one of the aims of the Rimini meeting is to learn about even difficult topics. So what he talked about are indeed difficult topics, but it's important to understand what the logic is that the Constitutional Court uses. That's very important because it opens up the topic of what is often mentioned, that is to say, the role of politics. Apparently, the Constitutional Court has legislated in the absence of a political decision. It has furthermore stimulated a political decision, which also means that we have a state organ that does not replace politicians, but it rather asks politicians, it asks politics to do its job. So I was very much struck by this. Now it has become much clearer. Now this three-party division of powers is much clearer to me, which has to be, in a way, referred to again to address topics, even ones for which there is not so much disagreement, looking for the compromise that I did at the beginning, because it seems to me that this is precisely what the court is doing. The court is asking politicians to do their job again. So to exercise the popular party that is such that one can actually solve certain aspects. And this is also what we hope for. So the presence, our presence with the meeting and then with the Foundation for Subsidiarity, everything we're doing is the idea of a situation in which people can decide. So thank you very much to Professor Barbera, who managed to make understandable to everybody a topic that is so difficult. And it's been also very pleasant to listen to you. Thank you very much.
Io ringrazio gli stimoli di Vittadini. Tu dici più democrazia.
Oggi abbiamo fatto la Corte Costituzionale, domani alle 5 incontreremo il Presidente del CNEL e sarà interessante nella ritrovare un organo costituzionale che ha una
civiltà dell'amore. Fratelli e sorelle, costruite senza stancarvi mai questa civiltà. Lavorate per questo, pregate per questo, soffrite per questo.
bello avere quello che ti serve quando ti serve. Con EasyBank, la banca digitale di Intesa San Paolo.
E allora si è voltato improvvisamente alla gente che era lì e ha detto: la gente che cosa dice che io sia? Chi dice che io sia? E voi chi dite che io sia?
È bello avere quello che ti serve quando ti serve. Con EasyBank, la banca digitale di Intesa San Paolo.
E allora si è voltato improvvisamente alla gente che era lì e ha detto: la gente che cosa dice che io sia? Chi dice che io sia? E voi chi